Okay, we'll give it about one more minute and then we'll start. For those of you who have just joined us, welcome to our webinar on Section 504 in schools. My name is Rebecca Shore. I am the Director of Litigation at Advocates for Children. And with me is Brianna Kitchell. If you want to introduce yourself, Bri.
Yes, good morning, everyone. Thank you for joining us. Like my colleague Rebecca said, I'm Bree Kitchell. I work with Rebecca. I'm a staff attorney here at AFC. Good morning, everyone.
So if you have not yet filled out the poll, please do so. And so that we can just get a little information about you and who we will be speaking with today. And we will start in about 30 seconds. In the meantime, as I said, if you could just fill out the poll, that would be wonderful and appreciated. Okay, well, why don't we begin? As we mentioned, for those of you who joined a little earlier, my name is Rebecca Shore. I'm from Advocates for Children, and I am the Director of Litigation here. And with me is Bree Kitchell, who is also an attorney who works with me in litigation and direct services at Advocates for Children. If you have not yet filled out the poll, please do so, and we are going to start. So if we could turn to the next slide, just so we could get the agenda. Let's see. Okay.
Is it not moving?
It is not moving.
Okay, give me 1 second. Sorry. I might need to redo this.
And while we're making that adjustment, we are going to be taking questions today through the Q&A button that is on your screen. We're not going to be taking live questions during the presentation. Those at the end of the presentation, if time allows, we will take live questions. But if you do have a question, please type it into the Q&A, and we will be reviewing those questions throughout the presentation and we'll be answering them at the appropriate times, either in that section, or if we know we'll be getting to it later, we'll make sure to answer it then.
Yeah, sorry guys, some technical difficulties. We'll get to it in just a second.
No worries.
And
okay,
tell me if you're seeing it.
So we see the first page now.
Can you see the agenda?
We can.
Perfect. Sorry about that.
No problem. Okay, so today we're going to be talking about Section 504 as it relates to schools. Before getting to the actual presentation about Section 504, we're going to tell you a little bit about Advocates for Children. Then we'll get into what the law actually is. What is Section 504 of the Rehabilitation Act? We'll discuss how Section 504 provides accommodations in schools, how to get Section 504 accommodations for students, appealing school decisions about Section 504. And then we'll talk briefly about bullying and Section 504, and then conclude. As I said, if you have any questions throughout the presentation, please put them in the Q&A. We will not be doing live questions throughout the presentation, but we'll be reviewing the Q&A. So if you have any questions that you want to ask during the presentation, please type them into the Q&A, not into the chat. The chat function is disabled. And then we will try to answer the questions during the presentation as best we can. And if you have questions that you want to wait to the end to ask live, if we have time, we will accommodate them then. Okay, so moving on to the next slide. What is Advocates for Children? We're an independent nonprofit agency that protects the rights of all New York City students. We have a variety of services. We have a helpline. The number is on the screen, 1-866-427-6033, in which anyone who has a question about schools and educational opportunities and rights in New York City can call. We encourage parents to call with any questions that they have, as well as providers and schools if there are any questions. We also do have guides and resources on our website, www.advocatesforchildren.org, including a just updated guide on Section 504 that you can find on our website. We do workshops and trainings, as well as webinars, and we provide free legal services to low-income families. Advocates for Children was founded in 1971 by parents of students with disabilities, and our mission has greatly expanded over the years. We have a number of different projects, including working on early childhood, charter schools, homelessness and homeless youth, immigrant students and English language learners, school justice, including school discipline such as suspensions and court-involved youth. We work in connection with child welfare involved families, overage and older students, and then as well bullying in particular for the LGBTQ students. Okay, turning to the next slide. As I mentioned before, we do a number of workshops. You can find them on YouTube. Just search for Advocates for Children and you will find our many workshops there and webinars on YouTube. Okay, so now I'm going to turn it over to Bree to talk about the law.
Hey, good morning, everyone. Just a reminder too, before I get started, this PowerPoint will be available to you. I know we link some resources throughout this presentation, so this will be available to you. Okay, next slide. So I'm going to talk a little bit about the law and what exactly this Section 504 of the Rehabilitation Act is. And basically, the law states that schools receiving federal funding must provide a free, appropriate public education, or a FAPE, to students with disabilities. It mandates that schools cannot discriminate against students with disabilities, and that a 504 plan provides accommodations for students with disabilities. Next slide, please. So Section 504 is in addition to the IDEA rights. So the IDEA is a provision of special education, and schools must provide a free, appropriate public education, or a FAPE, so that all students with disabilities can learn in the least restrictive environment, commonly referred to as an LRE. And also educational supports and services are provided through an individualized education program, also known as an IEP. Next slide, please. Okay, so what schools must follow in Section 504? So basically, it's traditional public schools run by the Department of Education, charter schools, and private schools that accept federal funds. And these private schools can include parochial or religious schools that accept federal money, and charter schools that are independently run public schools. Next slide, please. So you'll see that Section 504 gives two important rights to students in publicly funded schools. The first is that they cannot discriminate against a child who has or is thought to have a disability. And the second is they must provide reasonable accommodations and services so students with disabilities can participate in and benefit from the school program. And I'm going to toss it back to my colleague, Rebecca, and I will check to make sure that there aren't cute questions that we need to address now. And it looks like we're good. So Rebecca, take it away.
Okay, thank you, Bree. So now we're going to talk about Section 504 accommodations in schools and what accommodations are available under Section 504. Going to the next slide. This is going to get a little dense for the next couple of minutes because Section 504 is a dense law and has a couple of requirements, but you'll see in doing so, the requirements that it has actually make the number of students and people who are protected by the law very expansive. The first is that Section 504 protects people who have a physical or mental impairment that substantially limits one or more major life activities, or people who have a record of such impairment, or people who are regarded as having such an impairment. So it is not only people who have a current diagnosis of a particular disability. It also includes people who are regarded by others as having that disability, which we will get to in a little bit. Okay, next slide. Yeah, there we go. This is where there are a lot of words on this page. I apologize for that. This is what the law has defined as some of the impairments that fall within, some of the disabilities that fall within Section 504's protection. It includes both physical and mental, what they call impairments, including any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin, and endocrine. So as you can see, it does cover a vast array of disabilities, of physical disabilities. And then we're going to get to the what is defined as the mental impairments. Any mental or psychological disorder, such as intellectual disability, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Next slide. As we noted when describing the law, in addition to having a disability, it has to substantially affect a major life activities. The major life activities that the law defines are functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and walking. We have walking twice, apologies for that. Okay. Yep, next slide. There we go. And then the final requirement that the disability must have a substantial limitation of a major life activity. And the schools must determine if the disability limits major life activities without regard to use of medication, medical supplies, equipment, appliances, vision devices, such as glasses or contacts, prosthetics, hearing aids, and cochlear implants, mobility devices or oxygen therapy equipment, assistive technology, reasonable accommodation or auxiliary aids or services, learned behavioral or adaptive neurological modifications. This is very important. Before, we received some questions even before the presentation about ADHD. I just want to point this slide out in particular in connection with ADHD, but it really applies to any medication. The determination of whether a student is protected by Section 504 is by looking at the student without medication, meaning that if a student is on ADHD medication, seizure medication, antidepressants, and the school must look at whether the disability is substantially limiting or could substantially limit their life activities without the medication. It is not with the medication. And the The schools cannot say, well, the student is on this medication, so they don't need any accommodations. That is not the standard under the law. It really is looking at whether the disability limits major life activities without regard to the use of medication, as well as all of these other additional supports. Okay, going to the next slide. I just want to give a quick note about episodic impairments and impairments in remission. For example, seizures or asthma, where the disability does not manifest every day, but it does manifest in episodes. Those disabilities are still considered protected disabilities if they would substantially limit a major life activity when active. Okay, getting to the next slide. So here is a list of some of the disabilities that are covered by Section 504, especially in schools. There are others, but here are some of them: anxiety, asthma, ADD or ADHD, auditory or visual processing delays, cancer, depression, diabetes, dyslexia, epilepsy, HIV or AIDS, learning disabilities, limited or no eyesight or hearing, medically fragile children, mobility issues or physical disabilities, and severe allergies or chemical sensitivities. I just want to give a quick note specifically about allergies. Not all allergies are protected by Section 504. They really do have to substantially limit a major life activity. So for example, if a student has severe hay fever, but they are able to go to school, they are able to learn, that is not a disability that would be covered under Section 504. If, on the other hand, a student has a nut allergy that is airborne, and they would not be able to breathe in a cafeteria or another environment if there were airborne allergens such as from nuts. In that instance, a student would be protected by Section 504, and they would be able to get accommodations by the school in connection with that severe allergy. Going to the next slide. So what are the accommodations that a student can get? Three main components of those accommodations. First of all, the school does have to provide reasonable accommodations for the student. So what does that mean? They can't be overly burdensome to a school, and they can be different from what the parent requests. We're going to get in a moment to the process for requesting accommodations under Section 504 in schools, but it is important to remember that the accommodations must be reasonable, they can't be too overly burdensome, and they may not be exactly what the parent requests, and we'll get into how to best advocate for a student in connection with those requests. Going to the next slide. Going by category, here are some examples of services and accommodations that students with disabilities can get under Section 504. For students with medical needs, they can get medicine or nursing services during the school day, and there are a variety of levels of nursing services a student can get, either using the school nurse to administer medicine or medical treatments periodically for the day, throughout the day, or if a student needs more regular nursing services throughout the day as opposed to periodic times, they can get a either a one-to-one nurse or a nurse that is closely located to the student throughout the day. Students can receive periodic blood tests for blood sugar levels, the use of a nebulizer, removing particular allergens such as food, chalk, bleach, or pesticides from the learning environment, and learning in a chemical-free environment for chemically sensitive students. There are other medical accommodations that can be provided. These are just some examples. For students with physical disabilities, students can use the school elevator or a wheelchair lift and be in a building that is accessible for the student. Students can receive modified participation in gym or adaptive physical education. They can receive assistance of a health paraprofessional or nurse in school and or on the bus. And they can use a computer or other needed technology in order to be able to participate in the school day and in learning. For students with learning disabilities, students can use a recording device or a calculator. They can receive testing accommodations, such as having test directions and or questions read aloud, more time to complete tests, taking tests in quiet locations, and one that's not listed here, but is something that is helpful for students with ADHD. They can receive focus prompts during tests, so that if it looks like a student is losing focus on the particular test, there can be a staff member or a teacher in the room where the student is taking the test, reminding the student to focus, giving the student a break if the student needs a break, so that the student is able to then refocus on the test and get redirected in the way that the student needs. The students can also receive adjustments to their high school diploma requirements. For students with emotional and or behavioral disabilities, they can receive a modified classroom schedule. They can receive a behavior intervention plan. These are often used, given through the IDEA that Bree talked about, through an IEP. They do not have to be. They can also be provided through Section 504 of the Rehabilitation Act. Students can receive the assistance of a paraprofessional, and they can receive access to a guidance counselor or a social worker as they need throughout the day. So we're going to take a pause here and just look, see whether there's any questions. It does not look like there are. Okay. I'm going to turn it over to Bree then, who's going to talk about the process of requesting accommodations under Section 504.
Yes, thank you. So I'm going to talk a little bit about how to request accommodations under Section 504, and let's get started. Next slide, please. Okay, so the 504 process and how to request an accommodation in this area can really be broken down into four separate stages, and I will get into them in more detail, but generally the first step is to submit forms that the parent will work with their doctors to help fill out these forms when needed and submit them to the school. The second step in that process is the school will determine the student's eligibility under 504. And then the third, if the school finds that the student is eligible for accommodations under Section 504, the next step in the process would be the school holds what's called a Section 504 meeting, and we'll get into detail of what that meeting is, who's required to attend, and what is done at that meeting. And finally, after that meeting, there will be a determination of the students' needed accommodations, and then the issuance of what's called a 504 plan. So let's start talking about the first step, which is all about the forms. So the first step in the process is the parent will complete the forms based on the type of disability and accommodations the student needs. And these forms are provided on the schools.nyc website, and we've provided the link here. And as I mentioned earlier, you will be able to access this PowerPoint and click on that link. And within those forms, the really important component is that the parent and or medical provider includes a documentation of disability on that form as to inform the school exactly what the child needs within their disability. Next slide, please. Okay, so the three required forms. The first is called the parent request for 504 accommodations form. The second is the authorization for release of health information pursuant to HIPAA. And the third is the medical accommodations request form, which is the one that's filled out by the student's doctor. And we'll get into a little bit more detail on those in the coming slides. So the other important component of this process is the doctor's report. And I'm going to talk a little bit about what that is. So the important components of this doctor's report is that they identify what the student's disability is, what accommodations are necessary, and as specific as possible would be helpful as to the documentation in the forms. And then the third component is what would happen if the accommodations are not provided. Next slide, please. And once those forms are completed and filled out entirely, the school will hold what's called a 504 meeting. And there are certain requirements for both the procedures in place for this meeting, who attends, and also timelines after the meeting. So the meeting must be scheduled within 30 days from when the school gets a written request for Section 504 accommodations. And the 504 team will include the parent. It can include someone who knows the student's abilities, someone who can interpret evaluations, someone who knows services and accommodations, and if health services are requested, a school nurse or Office of School Health member. And at this meeting, the Section 504 team must consider all available and relevant information. Additionally, the parent has the ability to have these people who are knowledgeable about the student there. So if the school needs to accommodate those schedules as well, they can hold the meeting if the parent is wanting to have someone there, and they need to be as flexible, as possible, and make sure that the parent is informed of their rights as well. Next slide, please. So when a parent is requesting medical accommodations for the student, it can be broken down into different types of categories, and that is also corresponding to the different types of forms that are available. So for example, if the student needs medications in school, the parent should submit what's called a medication administration form, also known as an MAF. And this is separate. There are separate forms for allergies, asthma, diabetes, and seizure medications. If none of these apply to your child's medical needs, there's also just a general medication form. And for other medical services, the parent will submit what's called a medically prescribed treatment form. And this form may be used to request all skilled nursing treatments, such as tube feeding, catheterization, and suctioning, and some of the other services that Rebecca had mentioned earlier in this presentation. Next slide, please. And so if a student needs medication and other services, the parent should submit the MAF and the medically prescribed treatment form. These forms are available online or may be requested from the school's 504 coordinator. And an advocacy tip is, once the forms are signed and completed, make a copy for yourself and a copy for the school. Then submit the school's copy to the school nurse and request confirmation receipt in writing. And also, I know I keep mentioning the term OSH, that it refers to the Office of School Health, and they require families to submit new versions of these forms each year. Next slide, please. So if a student, for nursing services, as we had discussed earlier, there are specific components to advocating for a family to get these in a quickly and timely manner. If a student needs it, a school must provide school health services and/or school nurse services at no cost to the parent. And the school must schedule the Section 504 team meeting within 15 school days from receipt of the initial Section 504 request forms, which puts them on notice that this student requires nursing services. Next slide, please. With Section 504 accommodations and diabetes, there's just a little bit of a different process and timeline, but when the school receives what's called a diabetes medication administration form, or a DMAF, they must have a meeting within 5 school days with the parent, nurse, and other school personnel. If they can't immediately implement a Section 504 plan for the student with diabetes after the meeting, the school must provide interim care and services immediately following the meeting, such as blood glucose monitoring, insulin administration, and access to food and water during the school hours. Next slide, please. And now Rebecca's going to talk about the appeal process, but I want to first check in to make sure there are no questions regarding the process of how to request Section 504 accommodations. And it looks like there aren't. So Rebecca, take it away of the appeals
Great.
process.
Thank you. So as Bree described, there are a couple of steps in the Section 504 request process. First, the parent needs to submit the forms. Second, the school needs to determine if the student is eligible. And third, if the school determines that the student is eligible, the school holds a Section 504 meeting. And at that meeting, they make a determination of what accommodations the student will receive under Section 504. In connection with the school determinations, both of eligibility and what accommodations the student needs, if the parent does not agree with the school's determination, the parent has the right to appeal, to challenge the process. So we're now going to talk about what happens when the parent disagrees with the school in terms of the Section 504 accommodations that are being offered. First, let's go back a couple of slides. There we go. The first step in the process is that the parent can request a review by the health director of the borough field support centers for that particular borough where the school is located. The parent can request an administrative due process hearing. For those of you who are familiar with the special education process and special education hearings in New York City, the hearing officers who hear claims about special education also hear the claims about Section 504 if the claim relates to 504 in the schools. This is a required component, even if the hearing relates only to Section 504 and does not also relate to special education. The parent does need to request an administrative due process hearing through the impartial hearing office of the DOE, the New York City Department of Education, if it relates to a claim of accommodations in the school itself. After the hearing, if the parent still disagrees with the decision of the hearing officer, the parent can file a complaint in federal court. And separate from the hearing process, the parent can also file a claim with the U.S. Department of Education, Office of Civil Rights, and have the matter decided through the Office of Civil Rights instead. Next slide. Quickly, just a note about bullying and harassment. Bullying, if it is bullying on the basis of a student's disability, does fall under Section 504, and the school does have to protect a student against bullying related to disability harassment. So the two steps that are necessary in order to make a claim regarding bullying as in the schools. The first is that the parent needs to show that the bullying or harassment was because of the disability. And then also show that the school was aware of the bullying and did not take sufficient action. Typically, what this means is that if a parent hears about bullying of their child as a result of the student's disability, the parent should note in writing to the school that this is happening. The written notification to the school is key, because at that point the school is on notice that the student was being bullied because of their disability. And the school now has an obligation, once being notified, to take action to prevent the bullying. And if the school does not take sufficient action to prevent the bullying, the school can be held liable. The school can be sued for disability discrimination under Section 504 because of the school's action in connection with the bullying or harassment. So with that, we want to know if anyone has any questions. We do not see any in the Q&A. If you do have any questions, please let us know. And as always, if you need help, please ask. We have our helpline that you are able to call Monday through Thursday, 10 a.m. to 4 p.m. at 866-427-6033, or you can email us at info@advocatesforchildren.org. We do have one question. Okay, the question is, can feeding issues be addressed under Section 504? Absolutely. That is an accommodation that you can request under Section 504, and it is actually one of the accommodations that's provided pretty commonly through Section 504 plans. 504 or IEP, that is a great question. And I will say in New York City, oftentimes the school will focus on IEPs rather than Section 504. So even in those instances where a parent is notifying a school just about a disability that requires a 504 accommodation, it does not require any special education services. Schools are more comfortable with the process under the IEP, with IEPs and under the IDEA. So they may create an IEP as opposed to a 504 plan. The difference is twofold. One is that Section 504 plans are typically given or should be given if a student does not have any additional special education needs, does not need a designated class, a special class, or does not need related services related to their learning. That would be an example in which a Section 504 plan would be appropriate. In instances where the student also needs learning assistance in the form of a class or in a form of pull-out services or related services or push-in services. In those instances, the DOE in particular, the New York City Department of Education in particular, will create an IEP as opposed to a 504 plan. The other place that Section 504 becomes critical are in those instances that the student is attending a school that is not does not have specific obligations under or ultimate liability under the IDEA. So for example, in New York City, charter schools are not ultimately responsible. They are responsible under the IDEA, but ultimate responsibility for implementing an IEP and creating an IEP rests with the New York City Department of Education rather than the charter school. Charter schools still have an obligation under Section 504, and charter schools are the ultimate entity responsible under Section 504. So for students attending charter schools, very important to also protect the students' rights under Section 504, because the charter schools are directly responsible for the student in those instances. Students should have an IEP, and parents should definitely be making sure that the IEP is being implemented if they need an IEP, and also that Section 504 is that this charter school itself is protecting the student under Section 504 and providing the necessary accommodations that the student needs because of their disability. The same goes for private schools receiving federal funds. Those are instances where the private schools are responsible under Section 504, and it's important to make sure that the students are getting their accommodations in that way as well. I see that there is another question. A student can have a 504 plan and an IEP, and it sounds like especially in connection with medical accommodations, the DOE may be moving more in that direction of having 504 plans for the medical accommodations and then the IEP for the educational accommodations and services that the student needs. Ultimately, as long as there is a plan created that has all of the accommodations on it, the DOE would be fulfilling both the 504 plan, 504 accommodations and requirements, as well as the IDEA, if all of the accommodations are on the IEP. But a student absolutely can have both a 504 plan and an IEP, and in certain instances, it's actually probably a better way of accommodating the student, especially with the medical accommodations and physical accommodations. Are there any other questions? Okay, if there are no other questions, we do ask that you fill out the feedback survey. We read every survey that we get or survey result that we get, and try to improve our webinars that we provide based on the results of the survey. So please fill out the survey, and we thank you for joining us today. Again, if you need any help, please go to our helpline or send us an email, and you can always sign up to get more information. And you can get monthly updates in your inbox that provide for future workshops, changes in the law, know your rights materials, and updates on what is happening in New York City in connection with education. All right. If there are no other questions, thank you very much for joining us. And we will be sending out the PowerPoint shortly. Thank you very much.